And what's really revived this case, essentially, Nalini, in the Supreme Court? Because the last hearing happened 3 years ago, and if I'm not wrong, this was in March 2020, that the bench had refused, essentially, to refer the matter to a 7-judge bench. So what's really revived this entire case in the Supreme Court now?
Well, Akshita, like I told you, after the previous Chief Justice of India, Justice U.U. Lalit, had started his tenure, he'd taken an active decision to ensure that the Constitution bench matters are heard parallelly along with the day-to-day hearings. Because for a long time before that, we had not seen a lot of constitutional bench issues come up before the Supreme Court, which is why in the recent past, we've seen a lot of issues like demonetization get decided by the Supreme Court that had been pending before the court for a long time. So even though they've had very little impact on the ground, the Supreme Court is ensuring that it fulfills its duty and disposes of these matters. So since then, since this practice has come into being in the Supreme Court over the course of the past about 10 months, since then we've seen multiple requests being made for the matter to be listed on an urgent basis because it's been pending for a long time. And after the matter was referred to a 5-judge bench, and like you correctly said, after the court had said that it doesn't need to go to a 7-judge bench, after that the Supreme Court, there have been requests before the Supreme Court for the constitution of the 5-judge bench itself. So just a few months back, the Supreme Court had finally decided what the composition of these 5 judges are going to be that are finally going to hear this matter, and had planned to list this matter today to decide as to what is the schedule that is going to be followed by the Supreme Court in hearing the matter. Obviously, because it's 5 judges of the top court that need to take out time from their schedules and their day-to-day hearings, there needs to be an extra day that the Supreme Court needs just to decide the schedule, which is what they've done today. And they've decided from the 2nd of August, which is in less than a month from now, the Supreme Court is going to begin hearing this matter. It's going to be an expedited hearing. That's what we are expecting. There are going to be several lawyers who are going to be presenting their cases, obviously, because there are multiple petitions that are pending before the top court. We'll have to see exactly how the hearings proceed and how early we can expect for the arguments to conclude. But considering that 3 out of the 5 working days in the week, the Supreme Court from 10:30 in the morning till almost 4:30, or maybe even later in the evening, is going to be continuously hearing arguments in these matters. It shouldn't take more than at least 2 weeks for the arguments to conclude and for the judgment to get reserved. So a lot to look forward to in about 3 weeks from now when the matter comes up before the Supreme Court. But the centre is also facing a setback today, with the Supreme Court saying that their latest affidavit that they filed on the eve of the hearing, obviously expecting for it to make some sort of an impact on the judges, is not going to be being taken into consideration because it has absolutely no impact on what the constitutional questions pending before the court are.
So does this mean that the centre then files a fresh affidavit, Nalini, when the hearing resumes on August 2nd, when the hearing actually begins on that date? Will the centre be given another opportunity to now pose their arguments from a constitutional framework?
Well, Akshara, at this point, it doesn't look like that, essentially because the Supreme Court is very clear as to what is it that they have to decide. They don't have to compare the situation that is existing in the state before and after the abrogation of Article 370. Rather, they have to decide on the legality and the validity of the decision that was taken by the centre itself to abrogate Article 370. So keeping that in mind, the Supreme Court is going to keep its scope very limited because if they go into other aspects, then it's going to be like going down a rabbit hole and there's going to be no end to the hearing at all. This is what Supreme Court usually does in questions that require larger constitutional consideration. They try to limit the scope as much as possible so that not only can the hearing be expedited, but there can be also a better resolution of the issues that are before them. So for that reason, the Supreme Court is not likely to allow either the centre or even the petitioners to come up with any new facts, because what it seems like from what the judges have said, they believe that there has been absolutely no change in the constitutional situation compared to when the 3-judge bench was hearing the matter in comparison to now. So because there is no significant change in the constitutional situation, there is no reason for any additional affidavits or any new facts to be brought forth before the Supreme Court. So even if the centre wants to place any new affidavits before the Supreme Court, they will have to convince the Supreme Court to take it into consideration, because at this time, the Supreme Court judges seem a little reluctant to get into new aspects that have not already been chalked out by the Supreme Court benches earlier.
Interestingly now, in the Supreme Court, Nalini, both Shah Faesal and Shehla Rashid, who are petitioners in this matter, have now sought the court's permission to withdraw their names as petitioners as well. That's just happened in the court.
Well, yes, Akshara, as we know, that this is not something that is coming out just for the first time. Even earlier, we've seen Shah Faesal speak about this issue several times, where he said, expressed his inclination rather, that he wants to withdraw himself as the petitioner before the Article 370 matter before the Supreme Court. And as to why they want to do that is for them and their lawyers to decide. But what they're given to understand is that, yes, they've made a request to withdraw themselves as petitioners. It's a little shocking coming from the fact that petitions have been pending for a long time, and it's only now that these petitioners have made this request. But we'll also have to wait and see exactly as to whether or not the Supreme Court will allow them to do that. In all likelihood, it will be allowed by the Supreme Court to ensure that this happens. But like you said, the hearing is currently ongoing before the 5-judge bench headed by the Chief Justice of India. And what we're given to understand, what Shah Faesal has said, is that he wants the cause title of the case also to be changed, because once he withdraws as the lead petitioner in the case, the petition should not be on his name anymore. So we are still waiting for a response from the judges on exactly how they see this recent development, and we keep getting the live updates for all the viewers what Union to India today right now.